California High-Speed Rail Authority versus Superior Court. There are two sides in this case, we've determined, and each side in this argument will have 30 minutes to argue. I trust you've made your allocation of time between counsel, and the petitioner may proceed.
Good morning, and may it please the Court. I'm Deputy Attorney General Ross Moody, representing the petitioners in this action. In 2008, the people of the state of California approved Proposition 1A, authorizing the issuance of $9.95 billion in general obligation bonds to construct a high-speed train linking population centers in Northern and Southern California. The High-Speed Rail Authority has followed the template of Proposition 1A and has constructed a detailed plan to build this train. It has also obtained billions of dollars of federal money to assist us in this endeavor. But two decisions by the Superior Court of the County of Sacramento threaten to stop this plan in its tracks and prevent us from using this federal money. We ask this court to issue a writ correcting the two errors in the two cases below. Unless there's instruction from the court, I will start with the validation action.
You know, it occurs to me, you have 30 minutes, it occurs to me the issues in the validation action are extremely well briefed, and I don't know how you plan to, how you've allocated your time between those two issues, and you're certainly free to begin with the validation action, but I would hope that you'd spend the most of your allotted time on the mandamus proceeding?
I'm happy to do that. Let's start with mandamus. So in the mandamus proceeding below, the Superior Court issued a writ requiring the High-Speed Rail Authority to rescind its initial funding plan and resubmit it. And it did so based on the idea that the plan violated Subdivision C of 27408 of the Bond Act. And we believe that there are multiple errors present in this decision. The first of which is finding a private cause of action in the requirements of Subdivision C. Properly understood, Subdivision C provides information to the legislature, and it is the legislature's obligation to decide whether it has sufficient information. And this argument is rooted in the very language of Subdivision C, which says that not less than 90 days prior to seeking an appropriation of bond funds under Proposition 1A, the authority shall submit its initial funding plan. And then it says that it shall, and the words are, include, identify, or certify to 11 different things in that plan. Now, all of this is leading up to a yes or no vote on the appropriation requested by the authority. And to come in after an appropriation has been received and to say, we'd like to go back to that prior period in time and correct, augment.
If I can interrupt you.
Sure.
Let me ask you this. This requirement of a plan, the first plan, which I think you occasionally refer to in your briefing as the preliminary plan, this first plan is required to include some very specific items, is it not? Doesn't the proposition require that?
It does list 11 specific items, and the lead language about what those items are supposed to do is include, identify, or certify to, and then there are verbs in some of those 11 items
right,
as well.
And there's a whole list of 11 items.
11 items.
That the preliminary plan is supposed to include. The argument here is that the plan does not include that. And that the people must have obviously meant something to require the plan to include these particular things. So what effect, if any, is the language requiring the inclusion of a discussion, a certification, or whatever the language is, of these items if you're not required to include them?
It's not a question of whether you're required to include them or not. The question is where to adjudicate a dispute about whether they are included. And it is our position that the place to have that discussion is in the legislature. And I think the clearest way to understand that is by looking at what actually happened in this case. Because there was an 11-month gap between the time that the funding plan was filed and the appropriation was issued. And during that time, the legislature made a searching inquiry into the plans of the authority. And in the middle of that period, the authority issued a revised business plan that contained a lot of information that supplemented what was in the initial funding plan. There were hearings. Opponents of high-speed rail were brought before the legislature and spoke their piece. They brought representatives from the authority and grilled them in these hearings. And at the end of the process, that was the opportunity for the legislature to either say, we agree with what you've provided to us, we don't think it's enough, but we know that they accepted what was provided because they issued an appropriation. And we've done a searching inquiry through the record, and we can find no statement by a legislator criticizing the funding plan submitted.
Well, even if it did have a criticism, isn't it what the legislature did, not what somebody said about it in the process?
That is exactly right. That is the way Prop 1A is established. You see, we have two plans. One of them is to get the appropriation, and that's the plan that on which the writ was issued. But there's another subdivision that follows it, Subdivision D, and you have to submit a subsequent plan in order to spend any of the money. The language in Subdivision D says that prior to committing any proceeds from the bonds, from the prior appropriation, you have to submit an additional plan. And the requirements in that plan are very specific. They require you to update any material changes from the initial plan. They require you to validate that the plan that you're proposing can actually be done on a practical level. And at the end, after all of the consultants and the reports are done, you have to receive an opinion from the Director of Finance that in fact this can be achieved as written.
That's true. That's all of that's required. But it sounds like what you're telling me is that it really doesn't matter what the degree of compliance with the proposition in terms of what the preliminary plan, this first plan, has to include. The information that's in there doesn't really matter. All that really matters is that the legislature ultimately considers the plan in some fashion and appropriates and makes the appropriation. Is that really what you're saying?
I'm not saying that Subdivision C and the requirements in it don't matter. What I'm saying is that is not...
How do they matter then?
They matter to the legislature. And they are the lead up to either...
Okay, so the legislature is really the sole judge of the adequacy of the preliminary plan.
That's correct.
Yeah, isn't that what we're really getting to, that the court doesn't have any authority to second-guess the legislature when they pass an appropriation?
That's right, Justice Roby. And, you know, there is an opportunity for legislative review in Prop 1A. It's not as though it's going to slip by without legislative review. You're going to get your judicial review. You're going to get judicial review, but at the appropriate time. What we've done here is we've jumped the gun. We've intruded. The trial court has intruded in the legislative process, and there's going to be another opportunity to examine the plans of high-speed rail before it goes ahead and asks to spend the money. And at that point, when you're going to start putting contracts out to bid or actually committing the funds, that is the opportunity for someone to come to court.
Okay, well, maybe I'm jumping the gun a little bit too, but it sounds like you're saying a couple of things. First, you're saying that the content of the preliminary plan and the completeness of it, the sufficiency of it, is really a matter for the legislature to determine, since the whole purpose of the plan is to benefit the legislative inquiry into whether an appropriation should be issued. You're saying that, and then you're also saying, and maybe this is where I'm jumping the gun a little bit, because you're talking about the later funding plan, right? That this is only preliminary to that, and that this one doesn't really matter. It's what happens later that really matters. Is that what you're saying?
I wouldn't characterize it as one matters and the other one doesn't matter. What I'm trying to do...
Well, you've said that one matters only to the legislature. The preliminary plan, this first plan, only matters to the legislature, right?
Right. Well, we're here to correct an error of a court. And so I'm focusing on whether it was appropriate for the trial court to tell the authority to rescind its funding plan and submit a new one. And there is an atmosphere that's been created by my opponents that in some way we're trying to evade judicial review. We're trying to remove items from judicial review. So perhaps I jumped the gun, Justice Ray, in getting to that point. But I know that when you come to court and you tell judges that they have no role in something, that's not a popular argument to make. I also recognize
I don't know.
that...
It's not a bad argument.
And I recognize that, we have a document, Prop 1A, and it was voted on by the people, and it has to have some meaning, and you don't ignore it, you follow it. But we believe that we are following it, and we believe that if there is if there's a time for judicial review, it's not now. And, in order to really shine a light on why it doesn't...
Well, it doesn't really make any difference whether you think it's time or not. The question is, does the law provide it? Isn't that the issue? It's not something you get to choose, whether you get judicial review or not. It just seems to me that acts of the legislature it's a difficult issue for the court to say, well, legislature, we didn't think you did a very good job of legislating. Go back and try again. I mean, how many times can you do that? I just think that there's a serious separation of powers issue here.
I agree. There is a separation of powers issue, and what makes the error so profound in the trial court is that they recognized that they had that the trial court had no authority to interfere with the appropriation, but it still insisted that the plan be rescinded and resubmitted. And if you read C, subdivision C, that makes no sense at all. We've already received the appropriation. You're going to submit a plan requesting an appropriation that you've already received? It doesn't make any sense, and it is compelling an idle act. Now, one of the issues that...
I believe Justice Butts has a question for you.
Sorry.
Thank you. Is it of any salvation that the legislature, when it appropriated the bonds, that it included express stipulations? I mean, does that address at all the deficiencies, the alleged deficiencies in the preliminary funding plan?
That's an excellent point, and I think it does. It goes to our point that this initial funding plan was the opening salvo in a legislative process that unfolded over 8 months with a great deal of scrutiny. And then, as you pointed out, at the end, it was not just an acceptance of the proposal by the High-Speed Rail Authority. Additional requirements and stipulations were written into the appropriation, reacting to perceived criticisms of the plan. And that's why it would be nonsensical to make us go back and do the plan again, because the plan has already triggered this process, the process has unfolded, and we've received this appropriation. And it matters that we not interfere at this point, that we not throw up these roadblocks to the project, because we have this big pot of federal money that's sitting out there that we need to spend by 2017, and the federal government is asking us to do our part and to authorize our bonds and continue with our process. If we take a time out every time we file a preliminary funding plan for a couple of years of litigation over it, this process is going to drag on forever. And you have to keep in mind that what has been established in the trial court is a template for any funding plan that will come in the future.
Okay, help me to understand that. There will be additional funding plans. And when will those be presented to the authority for consideration? Well, how does this work? As the project goes on, we had this preliminary funding, what we're calling a preliminary funding plan, and then there's later funding plans. So how many funding plans will ultimately be considered by the authority and subject possibly to judicial review?
Well, it's not clear how many, because we're talking about using a funding plan to build I want to get the nomenclature right. The usable segment on each corridor or usable segment. So a usable segment is defined as having 2 stations.
Right.
We have a cap on the number that we're going to have of 24, and so the most that you could have would be 12 funding plans. But it
So
might
there'll be a funding plan for each usable segment.
Right, but it's not limited to 2. You could have one that had more than 2. So it would be a maximum of 12 funding plans, but probably fewer than that, depending on the way that the plans unfold and the engineering, et cetera, et cetera. But we're going to be back. The authority is going to be back doing this again. And
I know you are, so that's why I'm trying to understand it. So let me ask this. You've told us in your briefing that this preliminary plan is of lesser significance than what is the second plan. Because the second plan is the plan that determines whether or not the money can actually be spent. Is that the way it works?
that's right.
And how it can be spent is truly critical. So are there going to be a number of subsequent final plans, I'll call it second plans, for each of these usable segments?
Yes.
And each one of those will present the same issues as this one has.
Well, I guess I'd answer that by saying what we would like is to have litigation over those plans, because those are the plans that are going to spend the money.
You want more litigation.
I think litigation is a foregone conclusion.
You don't have to ask for it.
I'm not asking for it. If we could shake hands and not have any more, I'd do that in the hallway, believe me. But the point is that, when you're going to build infrastructure on this scale, you cannot add additional spots where you go to court when they don't exist in the papers. You're building in 3 years, if you use this case as a template, you're building in 3 years for each preliminary funding plan where you go to court and agitate over whether you've met the requirements, when that's not something for the court to decide. The legislature's free to do it. And, by talking about the other places that there might be judicial review, I'm simply pointing out that this project cannot just slide through without some inquiry if someone wants to make it.
There's going to be multiple opportunities to challenge various things. But I'm still trying to understand how what we're here for now fits into the bigger picture. We had this one preliminary funding plan that has been challenged as being inadequate, and the challengers wanted rescinded on the theory that you then can't do the final plan, which is the one that really sort of counts until you get the preliminary plan correct. I don't know if that's true or not, but it sounds like we're going to have multiple opportunities, at least, to challenge each one of these plans. So is there something of particular significance about the challenge to this first plan?
Well, yes.
Or is it like any other?
Well, in a way, it's like any other plan, but it's the first plan. We can't get this project off the ground. We're stopped because of this misreading of Proposition 1A. And, instead of proceeding on and developing our spending plan, we've been sent scurrying back to redo the initial funding plan for which we've already received an appropriation. And so it is because, we're at the precipice of actually getting this project into the next phase, and we are stopped. We're being told to go back. We don't think it's a proper reading of the law.
Okay.
One of the requirements was that we do this quickly.
Right. I'm truly just trying to understand. Mm-hmm. There's this plan to be followed by future plans, and in each instance will it be followed by an appropriation?
If it goes according to this process where we ask for money, when we ask for money, we have to...
You submit the plan, the legislature is going to consider it as incomplete as it might be according to the real parties in interest, and then the legislature is going to decide whether to appropriate money or not. But the legislature is going to make that decision the way, it sounds like, the way it makes decisions on every appropriation, using whatever resources that are available to the legislature to make those appropriation decisions, in addition to which they will have the benefit of this preliminary funding plan as an information resource. And then the legislature acts, the appropriations made, and that's it for that stage of the process, right?
That's right.
Okay, and then ultimately, well, maybe not ultimately, but later you get a final funding plan as to the particular segment that the plan relates to. And at that point, and that's a really critical point, right? Because that's where you're talking about whether they have the authority to spend the money. And it sounds like from the papers you've submitted to us is that it's at that point that this challenge that they're making ought to be made.
Exactly.
And we're too early.
We're too early.
Okay.
But you're saying that any subsequent of these preliminary plans will be subject to the same legal principles that you have raised in this case. When the legislature approves a plan, whether somebody thinks the material they had before the legislature was not adequate or not is not an issue if the legislature makes the appropriation.
I agree with that. I think that at the end of the day, when we go to spend money, we have these principles that where someone can come in and say, are you complying with the law? But the adequacy of the submission to receive the appropriation, I think, again, would be a question for the legislature.
Okay. You're going to talk to us about validation?
Well, I think I'm going to sit down and talk about it in the rebuttal since I have a little over 8 minutes left.
Okay, let's make sure there are no questions about that. Okay, thank you.
Thank you.
Good morning, Your Honor. Stuart Flashman for Real Parties in Interest, John Toss et al. And I'm going to be followed by Tim Biddle from the Howard Jarvis Taxpayer Association and by Blaine Green, representing Union Pacific, who are both going to talk about the validation. I'm going to start off talking about the writ proceeding and the funding plans.
Okay.
And,
you appreciate you only have 30 minutes total.
I do, yes.
Okay.
So we're going to try and split things up, and I'm going to take hopefully about 15 minutes on the funding plan issue. And I want to start off by talking a little bit about where this funding plan came from, how there came to be in the ballot measure a funding plan. And I think the point to start off with is a recognition that this is a very large, very expensive, and potentially very risky project. And the analogy I would make is to a rocket launch. Perhaps, for example, the Apollo 11 that landed men on the moon, which was also very large, very expensive.
Well, you really can't draw distinctions to other things. I mean, the State Water Project was built with bonds with not as many controls at all, and it managed to get there and serve the people.
Well, it sort of got there.
So it really doesn't make much difference what some other project needs. What we really have is what does the law provide for this particular project?
Okay. Let me talk about what this project, and I'm going to get directly to your point, Justice Roby, about the question of separation of powers. And I think an important point to realize here is this was put on the ballot. If this was just for the legislature's benefit, if the funding plan was only to give the legislature information, why put it on the ballot? Why not? Because a lot of this legislation, AB 3034, didn't go on the ballot. There's all of the parts that were not put on the ballot, didn't go to the voters, and were just approved. And they're still law, but the voters didn't see them. So why was this put on the ballot?
I'm not sure. I'm not quite sure I understand the point. Obviously, all of this was put on the ballot, but it doesn't. But it has a significance that we attach to that varies, doesn't it, depending on the nature of the requirement or the nature of the particular ballot provision. And this is one that the petitioners at least tell us was put on the ballot, and what the people had in mind was providing the legislature with information that would be useful in deciding whether to issue an appropriation.
Well, it was not just information, because what these actually acted as, the provisions of 2704.08C, those were essentially conditions precedent.
But Mr. Flashman, once the legislature decides that they're going to approve the appropriation, I just don't think that you didn't even make an argument you only made it in your reply brief that the appropriation wasn't appropriate. And that's what you're basically challenging now, is the validity of the appropriation. That's what the trial court said. That appropriation is null and void. You have to go, and the authority has to go put a new plan before the legislature, and we're telling the legislature, you go do it again.
Your Honor, I would have to say I disagree with your characterization that it was only, that was certainly what the trial court said. You only put it in your reply brief.
Well, that's illegal. In my mind, that's the effect of what the trial court said.
And
you're not disagreeing because you're supporting it going back and having the legislature do it again, are you not?
No, not necessarily.
Oh, really? Then what do you want them to do?
I think that would be the right thing to do, but it's not necessarily the only thing to be done. I think that to have the first funding plan done properly, which is what the voters expected, before you go on to the second funding plan, because the second funding plan is called, in the ballot arguments, it's called the updated, and in the ballot measure, the updated funding plan. Well, if it's updated, it means it's taking a funding plan that's there and now bringing it up to the current time.
You're still saying that the legislative approval of an appropriation doesn't, in effect, make the plan okay. You're still saying we can go back and insist on something be done as a condition precedent, even though the legislature has already acted.
I think that's, I mean, if under Shaw
Well, of any other law that ever provided for that, or any constitutional principle?
I would say Shaw versus People ex rel Chang.
Can I ask you this? I'm wondering what you lose by delaying this challenge until the second funding plan is under consideration. That is the plan that actually provides for the spending of the money. This only authorizes the spending, but if the money is never spent, it would seem to me, then you are in no worse position than you are now. So if you have an opportunity to challenge the spending, why isn't that opportunity enough?
I think part of the problem, and this was something the trial court recognized, is that the first funding plan requires that they indicate that they have finished the environmental review of the section they're going to build. Second funding plan says nothing about environmental review.
I understand. It says nothing about environmental review?
Nothing.
So you're saying that what you miss out on is an opportunity to challenge the failure of the plan to include
what you miss out is the guarantee that there will be environmental review done.
I'm sorry, what you're missing out on is the opportunity to challenge the failure to include environmental review.
That's certainly one of the things you miss out on.
What else are you missing out on? What else are you missing out on by delaying this challenge until the second funding plan is before the authority?
You're missing out on the legislature having all the information before it that it should have had before it to make an informed decision.
But the legislature had, according to Mr. Moody, the legislature had all sorts of information before it, not just the preliminary funding plan, but a host of other information. And the fact that the legislature was aware of the deficiencies in the preliminary funding plan were manifested in its inclusion of these stipulations in the appropriation. I mean, they're saying, in effect, we appreciate this preliminary plan doesn't include this, and this. So as a condition of this appropriation, you must do this, and this.
And how do they get around the fact that there isn't the environmental review already done?
Well, I think the answer to that, in part, is that they're not doing anything yet. All they got is an appropriation. When they actually propose spending something specific, there'll have to be a CEQA requirement. there will be it'll be a project under CEQA. There are lots of instances when there are interlocutory steps which are taken, which are preliminary. You don't have environmental review at every step. You have it when the step is the meaningful one, when something actually is done by the agency, whatever it is. Seems to me that they haven't lost any environmental review at all.
But let's take a look at that.
The legislature can't waive environmental review except unless they do it specifically, and they haven't.
But let's take a look at that, because what the ballot measure says is that you have to be able to certify you've completed the environmental review for the entire usable segment.
I understand that what you should be concerned with, and what you can litigate, is an environmental document of some type that you then allege is inadequate based upon whatever's going on. The only kind of environmental review that makes any sense is one that says there's something environmentally wrong with whatever project. Isn't that what the Environmental Quality Act is all about?
We've got a usable segment that's made up of subsections. Each subsection has separate environmental review. So you can do Fresno to Merced, which they are already wanting to start doing, without having gone past Bakersfield. In fact, without even having completed environmental review.
Raises an issue of segmenting of environmental review, which is not before the court today, and which might be before the court in an environmental lawsuit, but that's not this lawsuit.
Let me ask you this. Sorry. Is it? We'll get back to that. Let me ask you this. One of the stipulations that the legislature put on the appropriation, and we're talking about environmental review, no funds appropriated in this item shall be encumbered for the construction of a project prior to the completion of all project-level environmental clearances necessary to proceed to construction. Why doesn't that take care of the environmental concern?
Because
at least at this point.
Because the issue is, the idea of the ballot measure was that when you're going to do a usable segment, you get all of your ducks in a row before you start.
That's not necessarily the law of the Environmental Quality Act is going to be followed. That was the point I was just making. Before anything can be done, you're trying too hard in this case by bringing everything but the kitchen sink in at every step. You have to litigate, if you're going to litigate it, I'm sure you will, each step as it comes along. There will be a big environmental document, rooms full of paper, when they finally propose a segment. And one of the arguments you may be able to make is that it's segmenting it. It's not doing appropriate length of the consideration. Those are all things for the future, Mr. Flashman, are they not?
But what the funding plan is about is a usable segment. And it's saying, before you start building a usable segment, you need to be able to know you're going to be able to finish it.
Right.
And that means you've got to know you've got the funding, and you've got to know you've got the environmental review finished.
I see what you're... So you're saying you need that as to all of the segments.
Each of the segments...
Otherwise, the risk is you'll begin a system that cannot be completed.
Exactly. You're just stuck.
You'll be stuck at some point.
So you go ahead and you've got your environmental review done for Merced to Fresno, and you start building it, and you start going on the environmental review of Fresno to Bakersfield, and all of a sudden there's litigation, there's an injunction, you're stuck. You can't go on to Bakersfield.
That's a classic,
and yet you've already got this whole thing started.
That's a classic question of segmenting under the Environmental Quality Act.
Not necessarily.
Yeah,
it could be something very specific to Bakersfield.
You have to deal with it when you get there, Mr. Fleshman. This is not a review of environmental documentation.
It's not, but it is not the environmental documentation that the voters were concerned about. What they're concerned about is the integrity of the process and making sure that you can build a full segment when you start it. And if you're going to get stuck later on going over the Tehachapi's, you're not going to get that segment finished. And the point of the whole funding plan idea, again, like with a rocket launch, is to make sure you're going to get the whole thing done. You don't want to end up at T-minus 10 seconds and all of a sudden, oh my gosh, we can't go forward. So that's what was really the purpose of these funding plans, was to make sure you go through stepwise and you are sure that when you finally get to start construction, you're going to be able to finish that full usable segment. That you're not going to get stuck in the middle by running out of funds, by not having environmental clearances, by all of these different issues that are raised in that first funding plan.
But again, back to question I asked you earlier, don't you avoid that possibility if with this stipulation that the legislature put in this appropriation, assuming that it's placed in all the other appropriations?
Well, but all that's saying is you can't start construction on a segment on the, for example, the Merced to Fresno until you've gotten all of the project level environmental review for that segment that you're going to start construction. But that doesn't help if you haven't finished Merced to Fresno.
So you need all of the environmental clearances for all of the segments at the outset.
You need it for all of the parts of the of the usable segment.
At the outset.
At the outset, so that you know you're not going to get stuck partway through. That's what the ballot measure's intent was to make sure you're not going to get stuck with a partially completed segment that you're jammed up in with not being able to complete environmental review, and there you are with something that's of no use. And that was what the ballot measure was intended to assure didn't happen, and that's what the voters were promised.
So, Mr. Fleshman, if that is your position, is that why you would say that the environmental clearance provision doesn't appear in subdivision D?
Absolutely.
Statute?
It's because they expected it was all done. You don't need to deal with it again. It's done. If it was done right. And the fact that it wasn't done means you're stuck. You don't have a way of dealing with that with D because it's not there, because it was expected to have been dealt with in C. So it's really problematic. D doesn't get you out of the problem of not having environmental clearances for the full usable segment done. You're left with a problem that could end up jamming the whole thing to a halt with a partially completed segment, which is exactly what the voters didn't want and what the legislature, when they put the measure on the ballot, didn't want. And I know you'll say, well, but the legislature went ahead and made the appropriation. Well, the legislature that made the appropriation is not the legislature that wrote the ballot measure. Legislatures change over time.
I notice you have about 15 minutes left.
Yes, Your Honor. Why don't I move on then to the issue of the validation action. And I'm going to talk primarily about the question of did there need to be any evidence to support the decision about whether it was necessary or proper, whether or not it was necessary or proper to authorize the issuance of bonds. And I think it's really in a way, a very simple question. It's a simple question of administrative law, which is when you have a government agency that's making a decision, and even if you want to be the most generous and say this was a quasi-legislative decision, which gives you maximum deference to the agency, you still have to determine that it was not arbitrary, capricious, or totally lacking in evidentiary support. And the problem here is it was totally lacking in evidentiary support.
Let me ask you this. If this is such a basic principle of administrative law, somehow it would seem to me that there would be cases in this particular factual context that hold exactly what you said. And we haven't found any cases that have refused a validation because the committee or because of the lack of substantial evidence of necessary and proper. Can you point us to any?
So far as I know, there aren't. And I think the reason is because any reasonable agency will give you something. Well, say, here, this is what the project we're going to do, and this is why we need the bonds. In this case, they provided absolutely nothing. All they did was provide the resolution saying, give us the money. And there's nothing even in that resolution to explain why it's appropriate at this point to give us the money. If you look at other similar types of situations where, for example, there are lots of cases involving redevelopment agencies and validation of redevelopment areas and bonds for redevelopment agencies, and they generally do talk about this is a blighted area and this is what we're going to do and this is why we need the money to go ahead and correct this blight. And if there had been that type of information here, I mean, it didn't need to be much. All it could have been would be, we're ready to start construction on the Merced to Fresno segment, and that's why we need you to issue the bonds right now. That would have been enough. That would have been substantial evidence. But for whatever reason, and I don't know why, They didn't provide any evidence. There weren't even any appropriate whereas clauses in the resolution that they passed. There was nothing saying whereas we're about to start construction on Merced to Fresno and therefore we need money.
Okay, but you can point to no cases where one of these validation efforts has been upended because of a lack of substantial evidence of necessary.
I don't know, but on the other hand, I don't know that there are any other situations where no substantial evidence has been provided. I
There
was
are an
shocked.
awful lot of bond acts passed by the legislature, a lot of bonds issued for hospitals and schools and water projects and everything else.
And usually there aren't challenges to the
There
validation
almost
action.
always are validation actions. The bond council won't let you sell bonds without a validation.
And often those aren't challenged.
Okay.
So the issue is really when you've got some sort of a decision like this, and this was a particular momentous one. You're talking about $8.5 billion worth of bonds that are being okayed. And in fact, if they'd actually had them at the trial court, if you look at the transcript, the judge asked, well, what if let's say Bill Lockyer had been present there, and Bill Lockyer had said, well, as treasurer, I think it's appropriate that we issue these bonds because knowing what I know about finance, this seemed like the right thing to do. I think that would be, given his expertise, that would have been substantial
That
evidence.
would have been enough. Well, what about this consideration? What we're talking about, you can have validation actions for a variety of things, but here is to validate the issuance and sale of these bonds. And that's all. It doesn't speak at all to the expenditure of funds, to the expenditure of the bond funds. And I appreciate you have a whole host of objections to this project going on because it does not comply with Proposition 1A. I appreciate all of that. But again, we're back to the question of timing. Isn't the proper time to raise those objections at the time the money is going to be spent?
Well, I guess if we're...
Let me finish.
Yeah, sure.
Here all we're talking about is the issuance of the bonds. Then the bonds are sold, the money is then collected, the state treasurer has it, but it won't go anywhere. And in fact, if this whole endeavor just sort of falls apart, the treasurer can just return the money to those who bought the bonds, and it's over. So the really critical point is when the money is going to be spent. So isn't that the time to raise all of these objections rather than raising what you have to admit is a very technical objection? I mean, even you said if we did it over, all the treasurer would have to do is say, oh, it's necessary and proper, let's get on with it.
But it is important, otherwise why would they put it into the Bond Act?
Right. Okay.
I mean, it's there. The legislature does not engage in idle acts.
Well, no,
when
but
they
that's
put it in
illegal.
there must have been a reason for it.
Well, but whether they have to conclude by approving them, that doesn't mean they have to have findings or specific, other than just the ultimate question they're asked. But bond counsel, as a practical matter, or bond hold, nobody will buy a bond if they don't think that whatever they're going to finance with it is going to actually go ahead. So you've got so many protections built in that you don't have to kill the whole idea of whether the bonds could even be issued. This is just a threshold legal hurdle. It seems to me that's probably one of the reasons.
But it is a hurdle. It needs to be. Doesn't need much. It doesn't need much at all. But it does need to be gotten past, and they didn't. And to ignore that hurdle is to just thumb your nose at the provision that the legislature put there.
Well, assuming that there is a requirement, which you have no authority for, and that's the issue, really.
Mr. Flashman, it seems that you're asking us to basically identify the Finance Committee as just essentially a rubber stamp, that a request is made and out comes the authority. And that with the constitution of the people who are assigned to that committee, who have some financial expertise, it seems to me that we risk a great deal if we are to just assume that those people are not going to exercise their professional judgment in making such a decision.
If they were there, you would be right, but none of them were there. So I've got to stop because I want to give space for my other co-counsel. But I do want to just finish by pointing out that this is a provision of the Bond Act, and they have the committee has a special requirement here. Their expertise in an understanding about issuing bonds. It's not about the system. It's not about funding plans. It's just about bonds, and that's what the focus should have been, is saying, tell us why, there needs to be some evidence to show this is an appropriate time to issue these bonds. Thank you.
Thank you, Mr. Flesh.
Good morning. Tim Biddle, Howard Jarvis Taxpayers Association. I'm going to speak about Article 16, Section 1, the requirement of voter approval of a specific object or work. Whether the proposed bonds have been voter approved is contested. Our fourth affirmative defense alleged the bonds which are the subject of this action are to construct improvements for a project that is substantially different from the project distinctly specified in Proposition 1A. These bonds, therefore, have never been approved by the voters as required by the California Constitution.
Okay, I'm going to ask you the same questions I've asked before about the timing of the challenge that you're making. You could be absolutely correct. You could be correct that at whatever point in time the project that's planned doesn't begin to resemble the project that the people authorized. And no one is suggesting that challenge should not be entertained and should not be heard. The question is, are we there yet? At this point, when there's been no construction, and the only expenditure of funds has been of federal funds, not bond funds. If there's been an expenditure of federal funds, I don't know about that even, but no expenditure of bond funds, why can't that challenge await the point in time when the expenditure of funds is taking place? And in fact, I understand there is another action that's pending, that's proceeding in the trial court that provides an opportunity to raise those objections. But why raise them now in this proceeding, which doesn't have anything to do with the expenditure of the money?
The answer to that, Your Honor, is that there are two separate requirements in our state constitution regarding the sale of bonds. The first relates to voter approval. The second requirement relates to expenditure of funds. And our affirmative defense in this validation action to sell the bonds relates to the first requirement, the requirement of voter approval, which has in itself two parts. There has to be voter approval, and there has to be a specific object or work that's distinctly specified therein. If we don't make the argument now in the validation action, then we lose forever the opportunity to argue that that first piece of the Constitution hasn't been complied with.
But how can we make that determination now when the project is really still in the planning stages, and we know about planning as it pertains to projects of this size? The project undoubtedly is going to morph over time. It's going to change for umpteen reasons that I can't even imagine. So how can we make that judgment as to whether the project that's being built is the project that the people authorized until we're at a stage where construction is about to take place?
As a reminder, Union Pacific still wants to address the court, but let me answer that question. This project has gelled to a certain extent because the legislature, as admitted by opposing counsel, the legislature has appropriated money from this proposed bond sale for the 2012 business plan. That was SB 1029, which was passed into law in July 2012, and it appropriated $1.1 billion specifically for the bookend project that is the subject of the 2012 business plan. In fact, SB 1029 prohibits the expenditure of funds if the purpose is to go back to a true high-speed system rather than the blended high and low-speed system. So we do have a concrete commitment by the state at this point to go forward with the 2012 business plan, and in fact we have an appropriation of the funds from this proposed bond sale for that very purpose. So if we don't make the argument today in the validation action that the project has changed and that this is not the project that was approved by the voters, we will never have the opportunity to send this back to the voters for approval of the new plan before the bonds are sold. And we have this new plan, this blended plan, because the state has concluded that it can't afford the project that was approved by the voters.
You said before the bonds are sold, and what I was suggesting to you earlier is that it's when the bond money is being spent that's the critical point, not when the bonds are sold, since that can all be undone, the sale of the bonds. It's when the money is being spent.
How can the sale of the bonds be undone?
The money can be returned to the buyers. I mean, that's provided for. The treasurer can do that. I mean, it's not, I don't know that it's, I can't recall a time in my memory where it's been done, but that nevertheless is an option that's available. So it's back to, isn't the critical point when the funds are about to be spent. Although I appreciate your argument about the Begin project and all.
I think I need to yield my time to
Okay,
Mr.
thank
Green
you.
at this point.
Good morning, Your Honors. Blaine Green for Union Pacific Railroad Company. I'm going to try to speak as quickly as I can. Union Pacific has a unique position in this case. It's the only party in this litigation that actually runs a railroad. We also have a unique legal position, which is that the scope of the validation judgment that is being sought by high-speed rail is far overbroad. And Justice Ray, I believe some of your questions really got to this very issue and very concern that Union Pacific has, is that the validation judgment that the authority is seeking seeks to validate compliance with the entire High-Speed Passenger Train Bond Act, rather than just that the bond issuance was procedurally valid by the Finance Committee. That's just one small part of the High-Speed Passenger Train Bond Act. It's 2704.13. The form of judgment needs to be narrow. That's why Union Pacific filed an answer in this action. That's why we have appeared in our answer. We propose our own alternative form of judgment because of these other issues that could be raised in the event that the project is built with blended service, for example, which has the potential to disrupt Union Pacific freight rail. The idea is to run trains on Union Pacific existing freight lines. There are many issues like this that should be carved out from any judgment, and the judgment proposed by High Speed Rail Authority would validate compliance with all laws and compliance with the entire substantive requirements, including trip time requirements, that are not at issue in this litigation.
We have your argument in mind. Your time's expired.
Thank you, Justice.
I think I'll respond to the last point first, which
Please.
On the validation point and the breadth of what's being accomplished here. You're absolutely right, Justice Ray. We are only trying to validate that these bonds are valid debts of the state so that people understand that they will be paid. And questions about their use, which I think is really what Union Pacific is going at, can come later. And
So he has a valid point.
no. He does not have a valid point. Yeah, I guess maybe I'll start over. No, it's the idea is, the question is, are these bonds valid, and will an investor be repaid, or is that part of it still up in the air? This question about whether or not what you're going to do with the bonds is going to satisfy all the other requirements of Prop 1A, trip time, this dispute about a blended system, et cetera, that's something that can be litigated in the future, and it goes to the point of timing. And when you read the proposed judgment in the validation action, it doesn't foreclose any arguments of the type that he's making. You can make those arguments at a later point.
Well, is your proposed judgment the same as all the other proposed judgments that the state submits with bond approvals? Like the water project, like the veterans bonds, or whatever, their general obligation bonds?
It's very similar.
The point is I think makes sense that these are valid bonds issued by the state of California, the full faith and credit of the states behind them and all this, and there are no legal impediments to their issuance, and that's what the validation says, does not? Isn't that the essence what validation is?
That's right. And sometimes
why can't you just write give the same judgment that they've used historically?
Well, a lot of times when you do a validation action, it's for a very modest project, and you want to validate use at the same time. If you're going to build a courthouse or a parking structure or something like that, then you come in and you ask for a validation action. You've got your plans ready, and you say the bonds are good and the use is good, and we're going to get a validation on both. But in a project of this scope, or a project like the California Water Project, something that's going to unfold over years, it is prudent to take it stepwise and to say, let's get the bonds approved. We know there's no longer a question about whether or not investors will be repaid, and then we can save for later the question about the use of the bonds. As the project matures, you can take them as
but I think that would
spend.
I think that's what the Council for Union Pacific was suggesting, a narrow judgment. Isn't that what he was saying? Why is there a disagreement between you and...
He's saying it's not narrow enough, and we're saying it's actually perfectly narrow, going to... the point is that what we've asked for is the bonds were authorized to be spent in a manner coextensive with Prop 1A. So we have said that we want these validated, we will spend them in compliance with Prop 1A. Anything that can be done under Prop 1A, you can do with these bonds. And once that judgment is entered, there won't be a dispute about that in the future. But there can be a dispute when you go to spend the money, whether or not in fact it's true that the use that you intend to use them for does meet the requirements of Prop 1A.
Okay, could I ask you a question about another subject?
Yes.
Mr. Flashman tells us that the design of the initiative was that these environmental clearances were going to all have to be done at the start because this project is going to be built, system's going to be built in segments. And we don't want to risk the possibility that one or more segments can't be built because they're not, these environmental clearances have not been achieved, been obtained. So you need to do all of that up front. Otherwise, there is the risk that you're going to have these gaps in what's supposed to be a north to south system. And that is why the environmental clearances are so critical. And it's only the preliminary plan that includes that requirement of the environmental clearances.
Okay, it's completely wrong. He's completely wrong about the way Prop 1A works. And when you read Subdivision C, it talks about an initial funding plan for a usable segment. It's talking about an incremental piece of the project. And that is what you need to show some type of environmental clearances for. You will search Prop 1A for a requirement that you get environmental clearances from one end to the other. And the reason is quite simple. If you were to try to get environmental clearances for the entire train before you built it, by the time you got around to building it, those clearances would be stale, and you would have to return and do it over again. It would make no sense to try to accomplish that, and that is not what Prop 1A requires. It requires that as we go through this incremental building process, that for each usable segment, we get the environmental review. And when you look at the relationship between Subdivision D, the spending plan, and Subdivision C, the appropriation plan, what you see is that even if the legislature had not put stipulations on the money saying that you need to have environmental clearances, which I would submit actually solves the problem for us in this case. But even if that wasn't there, there is a requirement in the spending plan that you go through and you update any material changes to the prior plan. And that would include the issue of environmental clearances. It sweeps it right in. So if you have more or if you have a problem with them, you have to disclose that. Subsequent to that, you have to get a consultant to say that you can actually build that segment. And obviously, you would never be able to get that kind of an agreement, of an opinion, unless you had achieved the environmental clearances. And again, this sets aside the question of what the legislature has done to make sure that this happens. So the notion that the plan will evade this environmental clearance issue is simply false.
So, Mr. Moody, the subdivision K of subsection C, when it says the authority has completed all necessary project-level environmental clearances necessary to proceed to construction, we're talking about construction of that corridor or usable segment thereof?
That's correct. That's correct. And we know that from the very first lines in subdivision C, when it talks about building on a corridor or a usable segment. And so we're talking about the modest initial proposal, not the entire train.
Okay, can I ask you another sort of technical question? And it's help me with the math of all of this. There were 9.95 billion
Yes.
in bonds that are authorized by the proposition. How many have been? What number of bonds, amount of bonds, has been issued to this point, or proposed to be issued to this point?
So there was a prior bond sale that occurred before there was litigation, and I don't remember the amount. I think it was $500 million. I could get that to you if it's important.
And how was that authorized?
It was authorized by a bond opinion. It was before there was any litigation or any cloud.
The committee, the finance committee, authorized it?
Yes.
Okay.
Yes.
So there was that, and then there was the larger.
The one at
issuance.
issue, the one at issue here is for $8.6 billion.
Does that add up to the total amount that was authorized by the people?
I think so. But yes, I'm told that that's true.
Okay, so the math is okay.
Yes.
All right.
I see that my time is